So please tell us your name and roll number for this exam.
So my name is Adyasha-Aarohan. My roll number is 3000046.
Okay, now without mentioning your name, please give us a brief introduction.
Sir, I completed my schooling, that is my 10th and 12th standard from DAV Public School, Unit 8, Bhubaneswar. Thereafter, I pursued my graduation from University Law College, Utkal University. That is, I completed my 5 years BLLB. Thereafter, I have completed my master's from SOA National Institute of Law. My hobbies include drawing mandala art, and I also like to watch series in my free time.
Okay, any special achievements that you would like to share with us?
Sir, I was the highest scorer in my batch from 2015 to 2020 during my graduation.
Okay, means you got some medal or certificate for that?
No, sir. Sir, actually, during that time, Utkal University comprised of MS University, which is now the MS University, and ULC together. So there were 2 students who secured the same marks, and the person with the highest CGPA got the gold medal.
Okay, fine. What was your specialization in your post-graduation?
Sir, corporate law.
Corporate law.
Yes.
Okay. Give me some good reasons why you are interested in joining judicial services.
Sir, initially when I came into law because one of my acquaintances got into judicial services, and I was interested in pursuing law, but I was not really sure. But as I went on studying, I felt interested in the subject, and I felt that this is one profession where I can be a direct medium of rendering justice. I can be a direct medium of giving justice to people.
Okay. So you said that your hobbies are drawing mandala arts.
Yes, sir.
Which is your favorite theme?
Sir, so there is no theme as such. It is something that I do to calm myself, to relax my mind when, sir.
Mandala art is basically those like in the religious festivals which are done with colors.
No, sir. Mandala art is a specific type of art which is drawn with very limited resources. It is a repetitive pattern that is drawn mostly using concentric circles or geometric patterns, and within that space, we have to do repetitive patterns, some intricate detailing. It requires very minimal use of stationery, and it is very soothing and calming. It is often considered that mandala art is a therapeutic form of calming your mind. So whenever I feel a little anxious or I need to calm my mind, I try to do mandala art.
Okay, that is one hobby you mentioned. Then yes. Second hobby?
Sir, I watch TV serials.
Okay, watching TV. So what kind of TV serials you watch?
Sir, sometimes crime dramas, sometimes comedy.
Okay, so how will these hobbies, that is a mandala art, mainly, help you as a judicial officer, directly and indirectly?
Sir, hobbies are something which one pursues so that one can have a little relaxation from the monotony of everyday life. Sir, as I said, mandala art is something that calms my mind. It is often helpful in soothing oneself. So whenever I feel the work life, I feel that there's some sort of work pressure that is crippling me, I can often resort to mandala art to help me soothe myself better, calm down myself.
Okay. So what are your optional subjects that you have taken? 3 optional subjects?
Sir, criminal law of crimes, law of property, and personal law.
Okay, so let us start with when do you have your interview?
So 7th.
First day itself, yes. Right? Okay, so let us start with procedural law.
Yes.
So now suppose there is a defect in the pecuniary jurisdiction of a civil court.
Yes.
So will the decree be considered as a nullity?
No, sir.
No. So in which case, in which defect it will be considered as a nullity?
Sir, if the court inherently lacks jurisdiction, that is subject matter jurisdiction is, there is a lack in subject matter, there is a, it is instituted in the wrong court which does not have the jurisdiction, then it will be considered as a nullity.
Okay. Can you, in simple words, explain the difference between res sub judice and res judicata?
Yes. Sir, res sub judice is explained in section 10 of CPC, and res judicata is mentioned in section 11. The prime differences between both these concepts are, sir, in res sub judice, the matter is pending. There are two suits that have been instituted, one former and one subsequent, and one is pending in the court which has not been decided. While in res judicata, a matter has already been adjudicated upon. So the second difference that I would like to say is in res sub judice, it is immaterial. It is Can I take a moment?
Yeah, you can just think about it and.
Sir, in res judicata, it is immaterial which suit has been instituted prior. The prior suit will be considered the one in which the decision has been done. In res sub judice, the suit which has been instituted prior in time shall be considered to be the first suit, prior suit.
Okay. So, suppose a foreign court has given a judgment and it is to be executed in India.
Yes.
What is the process of such execution? Is it possible
Yes.
to execute a foreign judgment in India?
Yes, sir.
What is the process?
Sir, we can file a suit for that, and I think, sir, section 44 of the Civil Procedure Code, so I'm not really sure about it.
Okay. In what conditions it cannot be executed? What are the exceptions?
Sir, section 13 provides certain situations when the foreign judgment shall not be conclusive, and in those situations which include where it has been the foreign judgment has been obtained by fraud, it is opposed to natural justice. It does not. It is opposed to natural justice. It is obtained by fraud. It does not coincide. It breaches any law of Indian law that is in operation in the country. It is opposed to any international law that is operational.
Okay.
It is not on its merits also.
Okay. So, what do you mean by interlocutory orders, and when does the court give such orders?
Sir, interlocutory orders are those orders which are often given before during the continuance of a trial, before the trial has been before the proceeding has been completed, and that's all.
Okay. So let us come to evidence side. What is the concept of res gestae, and what is the most famous case law related to that?
Sir, section 6 of the Evidence Act speaks about res gestae, which says that facts which, though not in issue, are so closely connected with the fact in issue or relevant fact as to form part of the same transaction that they are considered to be relevant. Sir, R versus Bedingfield is one of the landmark judgments.
What is this R?
Sir, R stands for Regina, that is the Queen. It used to refer to the Queen since all cases used to involve the Queen as we refer to state now, it used to be Queen back then.
Okay. Suppose king is the monarch, then in that case, what they will use? Still they'll use Regina, or they will use some other term? Just okay, just check that.
Yes.
Okay. What is the difference between an advocate in India and a solicitor from the Indian point of view?
So an advocate is any person who has qualified the requisite examinations and who practices or represents a client in court. A solicitor is someone, for in Indian context, I know solicitor is someone who assists the Attorney General. Like,
Is the Solicitor General of India.
yes.
Normally speaking, according to Advocates Act, can advocates in India solicit work?
No, sir.
They can't. So still in one part of India, that solicitor, that is still, that concept is still there in Mumbai, in Bombay. Just go through it, okay?
Okay.
You have to be a part of a particular society and you have to clear an exam and then you can call yourself as a solicitor. Okay. That is only there in Bombay. Okay. You're strong in constitution?
Sir, I think I can answer, but I'm not very thorough because so it was not my option.
Yeah, but it's a basic thing
Yes.
because everything has to be done within the ambit of the constitution.
Yes.
Are you interested in legal news? Do you follow Supreme Court's rulings, etc.? So today morning, Supreme Court gave a landmark decision with respect to abortion.
Yes.
What was that?
Sir, it said that there shall be no there shall be no differentiation for abortion, that is from 20 to 24 weeks, that is to be allowed to women whether a person is married or not, and a woman is married or not, and if a woman has conceived a child even through marital rape, that she can abort it when it's permitted, that is 20 to 24 weeks permitted time.
Okay. What about a minor? A minor. Suppose someone has been sexually abused
Yes.
and she's a minor and she gets pregnant.
Sir, I think they can.
It will be also applicable.
Applicable to them.
Okay. Do you know who are the judges in this particular case?
No, sir, I will not go through it. I'll go through it today.
Okay. Father-son duos who became Supreme Court judges.
Sir, the present Justice, Honorable Justice D.Y. Chandrachud and his father, Y. Sir, I don't remember.
So his father was a judge or a Chief Justice of India?
I think he was a Chief Justice.
That is one example of father-son.
Yes.
Any other examples that you know?
Sir, I know N.V. Ramana, sir, but his father was not a judge. He was N.V. Ramana, sir's father came during his farewell. I had read that, but
Currently, who is the Chief Justice of India?
sir, Honorable Justice U.U. Lalit.
Okay. And before becoming the Supreme Court Chief Justice of India, Judge of Supreme Court, he was Chief Justice in which High Court? Is he from the bar or from the bench?
Sir, he is from the bar.
He is from the bar. So in our history of independent India, how many Chief Justices of India have been from the bar? Directly practicing advocates who have been elevated to the Chief Justice and went on to become the Chief Justice of India. One is Justice U.U. Lalit. There's one more person. So this is basically legal GK and all.
Yes.
Okay. How many women Chief Justice of India have we had?
Sir, none so far.
None so far. Currently, how many women judges are there?
So 3.
3?
Yes.
Okay. And there is a very good chance that one of them will become the Chief Justice of India.
Yes,
In
N.V. Nagratha, Justice N.V. Nagratha.
Okay. Coming to Odisha, what is the situation here? Who is the Chief Justice of Odisha High Court?
So Justice S. Muralidhar, but he has been transferred to Madras High Court today.
Currently, who is the Chief Justice of Odisha?
Sir, Justice S. Muralidhar is there, but today itself the news came that he is transferred to the Madras High Court. So I don't know if the next who will.
Okay. First, and currently, how many women judges are there in Odisha High Court?
So 1, Justice Savitri Rathod.
And first woman judge of Odisha High Court?
Not aware, sir.
Okay. So, yeah, we talk about the Constitution. So, Part 3 of the Constitution, fundamental rights.
Yes.
According to you, which fundamental right is the most important?
So I think Article 21.
Article 21.
Yes, sir.
Why?
Sir, if there is no protection of life and liberty, and life and liberty is taken away from any person without due process of law, then the society will be in jeopardy because there will be anarchy. There will be lawlessness in the society. Procedure established by Article 21 speaks of right to life and personal liberty, and which can be taken away only by procedure established by law. So,
Okay. Procedure established by law. So this concept of rule of law, it has been proposed by which jurist? Who proposed it?
Dice.
Dicey. Okay. So what were the components of A.V. Dicey's rule of law?
Supremacy of law, equality before law, and third
There
component.
are three components.
Yes, sir.
One we have not included in our constitution, two we have included.
Sir, I think due process of law, because we incorporated procedure established by law.
So currently what is the status? We have procedure established by
Yes,
law
sir.
or due process of law?
Procedure established by law.
Even after Menaka Gandhi case. What is the difference between procedure established by law? It has been taken from which jurisprudence, and due process of law, it has been taken by which jurisprudence? Taken from which jurisprudence?
So procedure established by law is, I think, from British Constitution.
British. Then, and
Due process is law from American jurisprudence.
yes. So earlier the position was that yes, whatever the parliament or the legislature passes, if it is passed properly, following the procedure, that is final. Okay, but from Menaka Gandhi case and other cases, okay, it has been held that the procedure, due process of law, okay, that also is important. Means that is procedure established by law, plus that whatever law has been made, it should be fair.
Yes.
Okay, it should be without bias.
Yeah.
So now the position in Indian law is that we are following a blend of both,
Yes.
little bit more inclined towards
Procedure established.
due process of law.
Okay. Sir.
Okay, that is the current status. Okay. What about Article 32? Don't you think Baba Sahib Ambedkar said that it was the
Hard and
heart and soul of Constitution?
yes.
Hmm? What is the difference between the writs of certiorari and prohibition?
Sir, prohibition is issued to a lower court to prohibit before a decision has been given, and certiorari is given to quash the proceeding. Once the proceeding has once been completed, that is, the court has usurped its power, that is, without jurisdiction it has done, or it has exercised in a place where it has no jurisdiction, or there has been some irregularity. To quash the proceeding, certiorari, writ of certiorari is issued.
Okay. So suppose there is a let's say a wanted terrorist. Okay, a common civilian spots a wanted terrorist. Does our Indian law, IPC or CRPC, give him the power to arrest him? Can a common citizen arrest a proclaimed offender?
Yes, sir.
Huh? Under which section? You remember?
So section 43 of CLASSES.
Okay. What are the circumstances in which that will come into play, and what are the exceptions to it?
Sir, if a common citizen, that is a private individual, sees a person committing, who is a proclaimed offender, who has been, is an escaped convict, or is evading arrest in case of a non-bailable offence, he can cause the arrest and produce him before the nearest police officer. If the police officer finds that he has committed a cognizable offence, then he can arrest according to section 41. And if he finds that it is a non-cognizable offence, then by ascertaining his address and other details, if he feels that arrest is not required, he can let him go on a bond or surety.
Okay. So, under Indian Penal Code, there have been certain changes in section 377.
Yes, sir.
Okay. So, and after those changes, now the LGBT community is even asking for regularization or legalization of same-sex marriages.
Yes.
What is your opinion? As a society, are we ready for that? Like in many European countries, it has already happened. And suppose the government asks your opinion. What opinion will you give? Should same-sex marriages be legalized in India?
Sir, in my opinion, it should be done because the individual autonomy, Honorable Justice Deepak Mishra in his judgment had quoted that individual autonomy, a person expressing himself with his individual autonomy and living with dignity is the highest form of freedom that an individual or a citizen can get. So, in my opinion, sir, with proper regularization, that is legal principles and statutes created for dealing with problems that could arise in case of succession, in case of divorces and other issues that could crop up, like in normal heterosexual relationships, homosexual marriages should be allowed, but subject to creation of legislations that could govern their conduct.
Okay. Section 300 of IPC deals with what?
Sir, culpable homicide amounting to murder.
What are the exceptions to it? How many exceptions have been given?
So 5 exceptions have been given. One speaks about if a person is killed in an act of private defense, it shall not be murder. It shall be culpable homicide not amounting to murder. If it is done by a public servant on account of his duty under the color of his office and without any excess force. The third is if it is done in a sudden fight in a heat of passion, it shall not be done where there is no hatred or no. It is instantaneous. And the fourth one is. So the fourth one is consent. If a person above 18 years of age consents to any act and asks another person and the other person does it by the consent of the said person, then it would not amount to murder.
Okay. So what is unlawful assembly and which section of IPC deals with it?
Section 141 of IPC deals with unlawful assembly when 5 or more persons assemble with a common object of overawing by use of criminal force any lawful act of parliament to overawe by criminal force any state legislature to take a right of way from any person. And to intimidate any person into giving up any right of way in overawing a public servant in discharge of his duties. In all these circumstances, it is an unlawful assembly when 5 or more persons with the following common objects intimidate someone.
Okay. So. Is there any evidentiary value associated with hearsay evidence, and what are the exceptions to it?
Sir, hearsay evidence as such is not a substantive piece of evidence, but the exceptions are in certain circumstances it can be considered to be relevant. That is, according to Section 6, in case of res geste, that is if a person, suppose a person who has been under an accident and immediately thereafter he says to the bystanders about the occurrence of the incident, then despite being a hearsay evidence, it can be considered to be relevant. Admissions and confessions, even though sometimes hearsay, that is under Section 32 and 33 are considered relevant.
Okay, suppose a person has given his dying declaration.
Yes.
Okay, and somehow he gets saved by the doctors and he's discharged from the hospital. So whatever here, the evidence he has given as dying declaration, will that be still considered as dying declaration?
No, sir, it won't be considered as dying declaration, but according to Section 157 of Indian Evidence Act, former statements can be considered in later testimony to the same effect. So it can corroborate what he had said earlier. It can be used for corroboration.
Suppose the creditworthiness of a witness has been breached.
Yes.
So will the entire evidence given by him be thrown out, or what is Supreme Court's guidelines or judgment regarding this, or some part of it can be retained as evidence?
Sir, one part of it is like in Section 154 of Indian Evidence Act, if a witness turns hostile, it is the Supreme Court has said that the entire evidence given by the witness shall not be thrown out. Any part which can be sufficiently corroborated and which attracts the trustworthiness of the court and the reliability, that part can be used.
Okay. So, can you tell me what are the main reasons for the huge pendency of cases with the Indian judiciary? That is first part of the question. Second part is, just after assuming office, Justice U.U. Lalit has brought about some changes in the rooster system, which within 1 or 2 weeks, it brought down the pendency around 17% in Supreme Court. Can you tell me what changes he brought about?
Sir, the first part, answering the first part of the question, so the pendency of cases in India have been huge. Coming to the grassroots level courts, lack of infrastructure abilities to lower courts, deficiency, that is the ratio of judges to the public is quite dismal in the lower judiciary. So I think that needs a little upliftment, more recruitments of eligible and efficient candidates for judiciary needs to be done. So the second part, I think. So what was the question? Could you please repeat?
What changes Justice U.U. Lalit has brought about, mainly in the rooster, okay, the Supreme Court, which has brought down the pendencies by 17%. It has increased the workload of the judges, but it has brought down the pendency in this very short period of time by around 17%.
So I'm not aware about it.
Yeah, this is a very technical thing. Okay, just go through that. Okay, what changes he has done? Some judges, brother judges also, they expressed their disappointment on that because it became very strenuous. At the same time, they were not able to give proper time to all the cases. Okay, basically what he has done, he has given certain days for certain works. So on these days, these things will be done. The rest days, other things will be done.
Okay.
So in that way, actually, the judges were able to decide a lot of cases. Pendency decreased. Okay. What is your opinion about the representation of women in lower and higher judiciary?
Sir, as earlier, the representation was quite low, but I think it has been rising. It has been on the rise, and because earlier, sir, female education was still considered quite less, and especially in a stream like law, very few women ventured, and even if they ventured, there was this clause of practice before a person could become a judge. So I think that women have obligations. So I think, sir, it dissuaded them from pursuing judiciary. But I think several factors, including the elimination of this clause of practice before a person can, and lowering the age of eligibility for judiciary has also been one of the factors. And increase in female-centric education has also been vital.
Okay. So, what is your opinion regarding this hijab controversy which is going on now? Do you think that we should allow religious dresses inside the classroom? As a student of law, what is your opinion?
Sir, no, I think religion symbols and religious practices should be kept away from education, especially educational institutions, and I think, sir, there is a need for uniform civil code in our country.
You think that uniform civil code should be brought irrespective of consensus? Any state that you know where uniform civil code is there in India now?
Sir, Goa.
Yes. Why? What is the reason? Why only Goa? Why not other states?
Sir, Goa for a prolonged period was not a part of India. It was under the Portuguese rule, and I think, sir, the lieutenant governor, the governor of
Yes, the Portuguese practiced it
yes, sir, sir.
in all of their colonies. So Goa has another state of India which has already started the process of implementing uniform civil code.
So Uttarakhand.
Uttarakhand, yes. So you think that suppose one community does not want it, should we still go ahead with it?
Sir, there should be consensus in getting adopting uniform civil code, because otherwise it would lead to communal disharmony in the country. And
Suppose consensus is not formed.
sir, I think it should be brought about. I mean, it is for the
Consensus or no? Okay. Who will gain maximum in case uniform civil code is brought?
So women. So women of any community, especially community from the Muslim community, because the practices that are against women, because there are codified laws for Hindus, and but there are no codified laws for Muslims as such. Their rights of succession, their rights for education, even basic rights in clothing, they are not given the choice. So I feel, sir, the women community is going to benefit from this.
Okay, what is the concept of polyandry and its legal position in Hindu and Muslim law?
Sir, polyandry is a term given when a female has more than one husband. Sir, in Muslim law, it is considered to be void. That is, it is not permissible, and even in Hindu law, it is not permissible.
Okay. Fine, so that will be the end of the interview. So, feedback, you can take it down.
So, sure.
You can take
I'll use that one. Yes.
So first, basically, but still then there was some hand movement, okay?
Yes,
Like, so that you can avoid. So sitting position, like this can keep your hand on your knees or anywhere on your legs where you're comfortable.
Yes, sir.
Eye contact was more or less good. So situation, content of the answers were good. जो parts of अपन जानना थे directly मना कर देले, so just continue with that. And intermittently that smile was there on your face, but still try करिए पूरा maintain करिए अपन. Don't be too serious because the content of your answer is good, so you will get good marks, okay? But don't be too serious. Basic serious educating interview, okay? बाकी किसी question, see whatever questions they ask you like in 15 minutes or max 20 minutes. Question okay. There will be some questions which you will not know. So if you don't know a question, just with a smile tell them that you do not know the question. Okay, do not bluff or guess. Bluffing ki guessing foreign. So that is just stick to that. If you know the answer, answer it properly. Don't know the answer, just tell them that I don't know. Okay, or I'm not able to recall now. Okay.
Yes.
So if I have to give you marks out of 100, you will get around 80-85 for today's interview.
Okay. Sir, can I ask a few things?
Yes, please.
Sir, I have actually done my master's in corporate law. So, sir, when I mention corporate law, if there are...
They'll ask you certain questions about, let's say, corporate governance. Okay. And the things which you have studied.
Sir, there is this column in the biodata where 3 main subjects have to be written from +2, graduation and LLM. Sir, in my LLM, I had many subjects, but sir, if I write company law, IPR, because that was my specialization, IPR. So if I write company law and IPR, sir, suppose they ask some questions that I'm not aware of. Sir, can I say that, sir, during my preparation for...
No, don't give any reason. Just say that I do not know.
Okay.
If you give a very, let's say, we ask you what is the difference between a patent and a copyright.
Okay, sir.
Okay, basic question.
Yeah.
So like, if you're not able to answer, just say. And last year, what I've seen is that even in many cases, they don't even go for that your CIF. They'll just bring it and keep it there. And they ask you questions. So last year, 95% people got their questions from law, from different aspects of law. Some were basic questions, some were in-depth questions. Okay, in OJS, generally they do not ask general questions, hobby, this, that. Very few people are asked. Okay,
Yes, sir.
and other 5% comes from your work experience.
I
So
don't
since
have.
you don't have work experience, it will be everything based on law mostly.
Okay, sir.
And for example, some current news which is related to law, those things also they can ask.
Yes, sir.
Okay, so that you can just go through.
Okay, sir. Sir, for the panel interview, do we have to slot the times like for Saturday or Sunday? Do we have to slot times like we do for one-to-one interview?
No. Panel interview would be, we will give you like 1 or 2 hours, 1 hour slots. For example, if you get a slot of 1 to 2 p.m.
Yes, sir.
So you have to come around 12:55 and it will be like ranked first come, first serve. Okay, one who comes first will be given the first number.
Sir, I have paid for 3 mocks. That is 2 one-to-one and 1 for panel.
So then you can come on Saturday. That will be better. This Saturday.
Okay, sir.
For
Because
the panel.
yes, sir.
Because what has happened is that you'll just stop the recording.